Okay, this is the narrated PowerPoint presentation for week 8 of our blended course on employee privacy. It's organized a little differently than the way the book organizes it, but I hope it'll give you some further background as to why things are the way they are, as well as some common law claims that employees might bring in a workplace context that aren't covered in the privacy chapter. So let's get on with it. Next slide. Now, what do we call the right to privacy? What's the nature of it? It is the right to be left alone. The Europeans call it the right to be forgotten. It is a right that is recognized in the federal constitution, not in the writing. If you look for it in the Bill of Rights or any of the amendments or the body of the Constitution, you won't find it. The right to privacy, though, is well established as a precedent from the Griswold versus Connecticut case in 1965. That involved a state statute that forbade uh, consenting adults from using contraception. How times have changed. And the head of Planned Parenthood in Connecticut decided to bring a test case, made it obvious that she and her husband had used contraception. Those particular facts are lost to history. But suffice it to say, she pled guilty to having violated this statute and decided to go for the appeal as a test case. And remember, the test cases are great if they go your way, otherwise, they're horrible because they resolve any uncertainty against you. Well, the case got to the U.S. Supreme Court, and one of the most creative justices in history, in addition to being one of the longest serving, was Justice William O. Douglas. And Douglas used an astronomical analogy or metaphor to describe the location of the right to privacy in the Constitution. He said, you know, when there is an eclipse, there is the total eclipse area, and that is the umbra. That is where the light is totally blacked out. But then there is also a penumbra on either side of the more extreme um, part of the eclipse, and that is a partial eclipse. And he said basically, if you take the spirit of the First Amendment on freedoms of speech and association and religion, the freedoms to be left alone in those matters, against government interference, as well as the Fourth Amendment freedom from unreasonable searches and seizures and trial by jury of your peers, all those sorts of things, you sort of roll them up and you get something that looks very much like a right to privacy, a right to be left alone by the government. And so the majority of the Supreme Court announced this new right. It is perhaps one of the more extreme examples of activist judging because you won't find the right to privacy in the black letter law. But there it is, and it has been upheld in many instances since that time, so that it would be very difficult even for this court to get rid of a right to privacy. Next slide. There is in the workplace a tension between the legitimate interests of the employer in gathering information about employees in general and employee conduct on the job and even off the job in some cases, as we'll see, and the employee's right to be left alone, right to privacy. There are different rules elsewhere, and especially in the EU, where they're much rather more sophisticated in these matters than we are at this point. Silicon Valley has had a pretty good run of saying privacy is dead, get over it, and having legislatures not take up those causes. I think that time is coming to an end, but we'll see over the next several years whether it gets more play in the halls of the legislatures than it has in the past. But uh, especially in the EU and elsewhere, privacy means different things, and wherever you are, wherever you're conducting business, you'll need to know and be guided by those rules. The other part that we should not lose sight of here is that let's assume you have the right to collect the data. Then there's also a duty to safeguard the data and not to use it for purposes other than those for which it was collected in the first place. So recognize that once you've got it, you've got to keep it safe and not use it in ways that might embarrass and thereby violate a reasonable expectation of privacy on the part of your employees. Next slide. Now, it is true that there is no absolute right to privacy. It is this kind of balancing test between the interests, legitimate interests of employers and those of employees that are in tension with each other. The federal Constitution obviously does not protect any employee right to be free from unreasonable searches and seizures or any other Bill of Rights type protection. Um, it's often said that if you believe that the First Amendment applies in the private sector, try telling your boss what you really think of her. If you expect to be immunized from consequences, good luck. So it is important to recognize that constitutional guarantees will apply, including the right to privacy, when the government is the employer, as in many school situations, police situations, firefighter, first responder, prison guard, DMV, all of those folks. But we're dealing primarily here with private sector coverage, and it is relatively sparse still, and somewhat surprisingly. Now, there are some states, and of course, including our fair California, which have a right to privacy stated in the black letter law of the state constitution, and we'll see how that comes into play, because it does have some private sector bearing, unlike the U.S. Constitution. Next slide. So, recognize too that all employees are safeguarded by common law protections against invasions of their privacy. The key is to define areas and situations in the workplace in which employees have a reasonable expectation of privacy. That's a phrase of art. It comes up in all the cases, and it is an attempt to determine when you ought to have the right to be left alone versus when you might expect that you would be monitored or that there would be access to material in your files, your briefcase, your mobile device, your company car, etc. So, and recognize that function creep is a problem. It's not the admin down the hall. It is the use of data beyond that purpose for which it was legitimately originally collected. Next slide. So, where can one reasonably expect there would be privacy in the workplace? Your body and physical space with regard to things like drug tests. There is a reasonable expectation to be free from a pat down or a body search. Normally, private locations, your wallet, your briefcase, your purse, those would normally be considered places where you would have an expectation of privacy. And then personal information housed elsewhere that is accessed without your permission. We'll see more of this in a minute. Next slide. So, again, no constitutional protection in the in general in 49 states, in private sector employment circumstances. Only in California is there some, and it's a balancing test. Um, and the fact that there is very little in the way of statutory law gives you the freedom to craft policies that make sense and suit your needs and your company culture. You may want to say that you have no expectation of privacy when you show up here, um, or you may want to say, announce in advance that everything on your computer and in your voicemail logs and on your company issued mobile device, in your company issued car, is fair game for monitoring or inspection by the company, and thereby remove any idea that there might be a reasonable expectation of privacy in those things. But you do want to tailor it to your um, company culture, because that can appear somewhat intrusive and petty. And if you don't mind that, then go ahead. But the point is that you ought to craft a policy that meets your needs as a business, and you have the freedom to do that as long as you have adequately informed your employees of those policies. Always a good idea to get them to sign off on something acknowledging that they are aware of that policy. And it's possible to do that without triggering a wider um, need for a consideration or a bargain in those arenas. Uh, that phone will stop ringing eventually. The So it's up to you to do, and you have the freedom to create the environment that best suits your corporation. Yeah, it's my phone going off. So, um, with that, we can go to the next slide. Now that we've been so rudely, um, little statutory protection for private employees on the state level, um, but there are common law torts that apply in the workplace equally as they apply elsewhere. A tort being a private wrong in which one person causes injury to another. It does allow the injured person to sue the alleged wrongdoer to collect damages. Next slide. What are some of these protections? The first is what you think of as invasion of privacy, the intrusion into seclusion. A wrongful invasion of privacy that would be objectionable to a reasonable person. If the boss goes into your files, finds out where you live, and comes to your house at night, um, probably for romantic purposes more than to give you another dose of work that you might be expected to complete by dawn, that can be a wrongful invasion, and there have been cases on that point. There's also the issue of public disclosure of private facts. Now, there's maybe information in your file that you would just as soon not be open to the public and generally known. If your employer somehow allows that um, information to become public, then the employer will have violated this particular tort, and you would be due damages. The case of Yoder versus Ingersoll Rand is a case where both a mother and a son worked for the same company. The son had gone to the doctor and had been diagnosed with HIV. The doctor's letter apprising him of that test finding was sent to the workplace. and addressed to him. Well, the workplace knew that he wasn't there that day, but that he lived with his mom, so they gave the letter to her, and she did what any self-respecting mother would do. She opened it, and she thereby found out that he had HIV, much to his chagrin. He did not, however, win that case because there was no disclosure. There was no negligence involved. Um, there was no basis for knowing that was anything private in that letter, and so the fact that she opened it in an unauthorized way was not the kind of publication of those private facts that gives rise to the cause of action. So you have to be aware of these possibilities, but they're not everyday occurrences. Next slide. Publication in a false light is where there was a public disclosure of facts that misrepresents the individual. There was a case of a particular employee who it had something to do with her having slept around and bragged about it to her friends. But when it showed up in her performance review, it was she thought that it may portray her in a false light, when in fact it didn't portray her in a false light. It was an accurate light as far as the statement was concerned. So it may have been embarrassing, but it was not a breach, and she had waived any privacy rights by bragging about it. Defamation can be in written or oral verbal form, and so a false statement, for instance, in a performance review or in a reference that damages the reputation of an individual can give rise to a defamation lawsuit. And if that false information shows up in a an interview situation where the person is compelled to tell why he or she left the prior job, it can show up there as well. Again, not usual, and in every case of defamation, truth is an absolute defense. And finally, there may be contractual provisions in a collective bargaining agreement or in the employment situation that could give rise to a breach of contract for a disclosure of some private fact that is in the possession of the employer. So you do have those common law situations that you simply have to be aware of and avoid. Next slide. What about regulation of off-work activities? The general rule and the handbook and my sources have a somewhat different view of these things, but generally private activities may be regulated if it affects employee performance. And so there are all kinds of rules that employers attempt to enforce with their employees. They are often honored in the breach, but if they become the basis for a termination, for instance, they will hold up. There are state statute exceptions. Some of them in tobacco states deal with prohibitions against smoking. And in a New York case, there was a statute in New York State that forbade employers to prohibit any legal recreational activities. When a when when an individual was fired for dating a coworker, which was against the company policies. The court opined that dating is serious business and certainly not recreation as far as the state statute was concerned, and allowed that firing to proceed or to be exonerated. It, but you really do have to decide what your policies are going to be in this regard. We are biological before we are employed or rule followers, and in my experience, anti-fraternization policies are mostly unnecessary unless it's chain of command and just drive the behavior underground uh, as opposed to precluding it. With regard to many of these off-duty things that you might want to have a policy about, weight, for instance, or alcohol or tobacco or drug use, you might want to use a carrot approach as opposed to a stick approach for those who quit, for those who lose weight, those sorts of things. Although I had a 5 pound challenge when I worked for Conoco in Houston, and if you lost 5 pounds in a month, you got a T-shirt. And I had dinked around the entire month and lost nothing except I went out and ran for an hour in the Houston heat at lunchtime, and sure enough, I had lost my 5 pounds of water weight by the time I got back. I wouldn't do that at this stage of my life or physical condition, but back then it made sense, and I did get my T-shirt. Again, a reminder that U.S. companies with operations in the EU must comply with the EU's privacy and data protection laws. Next slide. Now, what about information gathering and justified use, disclosure of information? Obviously, proper documentation is an HR function generally, and if you don't like documenting, don't go into this particular profession. But there are risks in information gathering. If you are requiring it from some employees but not others, you might be giving rise to discrimination risk, not discrimination risk. If you fail to properly manage the data, if you improperly disseminate it, each of those things could give rise to some legal liability. There is the thing called function creep, where a data that is collected for one purpose is used for another, generally not a good idea. And both the collection and the retention should be conscious policies and transparent policies so that your employees know what their situation is. Next slide. Um, there are issues, particularly among these bullet points. The bring your own device situation is particularly gamey because it is difficult for the employer to legitimately exercise rights over information that is stored on the employee's own device. It presents practical issues as well as legal issues as to who owns it. The better part of valor here is to issue devices, company devices, where you have a complete right to that information and you can limit the use of it for company purposes. We've talked about references. You should also recognize that there is an epidemic of admin password abuse. Those guys get bored and go where they don't belong. And so you simply ought to take into account that the admin may be snooping around in the files of the individual that strikes their fancy, or they have a vendetta against, or something. So make sure your admins are, number one, trustworthy, and even if they're trustworthy, have authentications that don't give them free rein to rummage about anywhere in your computing systems. Next slide. Now, what about monitoring of employees on the job? It has a rich tradition, time and motion studies. It does raise some ethical and legal concerns. What is a computer good for? It's good for gathering, uh, developing, and storing information. And there is a current uh, trend toward productivity measurement management. You can keep track of all kinds of productivity measures, whether it's calls per hour, duration per call. There are even relatively inexpensive bits of software that will monitor fannies in seats. So you know that the person has been there in his or her seat for X hours per day. New technologies of GPS, you can tell exactly where your employee is. Radio frequency ID, biometric IDs, all of these things are new and need to have policies developed around them. Next slide. Um, Statutes at the state level have begun to address surveillance and monitoring. We'll talk about the Quan case when we get to California in a few minutes. But business justifications are receiving weight in the early cases, especially when the when the information is stored on employer-owned instrumentalities, and especially when the consent and foreknowledge of the employee has been obtained. So courts do favor and notice those provisions that indicate that the employee is aware that this kind of monitoring can be done. California forbids compelled access to passwords like on your Facebook or any other social media, um, with very limited exceptions. Next slide. So the what the lesson is here is that you still do have the freedom to establish your company policies and do it in service to creating a managed system, a system that meets your needs and meets your culture and is clear and as transparent as you can make it. Next slide. With regard to monitoring of emails, you have this tension of the employer need versus the employee right to privacy. The Electronic Communications Protection Act at the federal level only exists in the actual interception of information, not when it has come to rest. So if it's come to rest in your business files, your employees' business files, there is no there's no application of the ECPA, and the cases have been very employer focused and friendly with regard to saying there's no reasonable access or no reasonable expectation of privacy on the employer's instrumentalities. That's true even when the employer has said, we won't monitor these things. There was a Pillsbury case that involved a guy who got fired for talking in some disparaging and vaguely threatening way about a company event. And there was a Harvard divinity professor who was storing kiddie porn on his Harvard issued computer. And even though Harvard had said we'll never go in and monitor this stuff, somebody who was in servicing the computer noticed the kiddie porn, notified authorities, and Harvard was upheld in its um, pursuit of termination of that individual and reporting to the appropriate authorities. The if you want to do a test case using kiddie porn as your test is never a good idea. It is very difficult to get a court to ever decide anything to do with that abomination is ever going to be legal. Next slide. So, develop policies with regard to these several burger dots or bullet points. The coverage, employee access, um, job relevant information. If you ban continuous monitoring or secret monitoring, or if you don't, that should be clear. But the authors, at least of the book that this is based on, suggested not to, and to limit your guidelines to your true business interests. Next slide. Okay, let's look at California in particular because, as we all know by now, California is different. In the California State Constitution, Article 1, among the Declaration of the Rights of the People of California are the rights to safety, happiness, and privacy. Now, privacy wasn't in there until it was added around 1970 by one of the propositions voted on in a state election, but there it is in black and white. So California gives a pretty strong public policy import to privacy. Next slide. And what we see is first off, you have to recognize that as opposed to the federal constitution, the California right to privacy will apply in both the public and private sectors. And very clearly, California has announced a balancing test between the competing interests of the employer and the employee, the employer to the information, the employee to be left alone. There's no privacy expectation in your trash, and so no search warrant was required to retrieve information of a crime by the police when that information had been discarded in the dumpster. But a cell phone search after arrest requires a warrant. Okay, so you see there are ways that privacy is considered an important interest. Now, NCAA versus Hill involved drug testing of student athletes, and the court came out with saying that urine test, somewhat publicly administered, did not violate the athlete's California right to privacy. The court did discuss the fact that if you're on a team, there is a locker room, there are showers, etc., and there's already a reduced expectation of privacy. And it is announced in advance that there will be this testing so that it can be avoided if it's that important to the particular student athlete. So that's one example of the right to privacy in California. Next slide. In Loader versus Glendale, I think I mentioned this in the wage and hour stuff, a pre-employment drug test is reasonable, but suspicionless drug tests in promotion contexts violates employees' privacy. The idea is you don't know enough about this individual before you hire them, but if you're in the process of promoting them, you know a lot more. And so, whereas the employer's interests are paramount in pre-employment, they aren't uh, in promotion circumstances on a suspicionless basis. Kwan versus City of Ontario, the employer searched a pager because they were trying to figure out, frankly, uh, whether they ought to be offsetting more costs of the pagers that were held by their city police officers. Turns out that this particular officer was running some sort of an adult business out of his pager and was disciplined for that. Um, but the search was found to have been legitimate at its inception. That is, it had a proper purpose. It was limited in scope to that purpose, and it didn't go fishing. They just couldn't help but find the evidence that they found on this guy's pager. Next slide. Um, there in California is broad coverage of privacy rights in a variety of realms, but much less so in employee rights. There are some pre-employment issues, and I've given you a link to that. We've talked about the drug testing. Most information in background checks is fair game, but with notice and permission received and a copy provided if requested. Credit reports can only be used in sensitive occupations, and social media passwords, as indicated previously, may not be required by the employer so that they can root around in your social media uh, accounts. The bigger problem in social media and why you need to monitor it is that you may have, quote, friends, close quote, who will publish that photo of you dancing on the table that may have career altering impacts. And so you do need to be careful. And frankly, my younger daughter, I don't know that she's in the habit of doing that, but she is there under her mother's former name um, and and under a nickname, so that it is not evident that if somebody went fishing to find out more about her, an employer or not, she'd be tough to find. A word to the wise, I think. Um, Next slide. Finally, when we look at post hire, um, the employees do have rights to documents that are collected about them. There is a 7-year rule on maintaining arrests and convictions. Um, and we've talked about the ban the box stuff in the context of the employment life cycle. The employer can't ask about earlier or other convictions that have been longer ago than 7 years. In other words, you're not required to disclose it, and the employer can't ask about it either. Next slide. Video surveillance is limited by Labor Code 435. No restrooms, locker rooms, change rooms, showers, but most other places will depend on the facts. There was one case that involved video surveillance of uh, inmates when they checked into the jail and would turn over their personal effects, which would be held for them. That video surveillance protected everybody's interests in um, ensuring that the inmate got back his or her property at the end of their stay. Um, Two-party consent is required in California. It's implied when they say this call may be monitored for QA, QC, or other purposes, and you stay on the line, that is implied consent. There are simply no protections for employees with regard to their email or their voicemail records and the monitoring or audit thereof. Next slide. Finally, with regard to off-duty conduct, very much a gray area in California. Labor Code Section 96 appears to prohibit employee consequences, that is, employer rules against lawful off-duty conduct, but the interpretations are very fuzzy and incomplete. In Barbie versus Household Finance, a boss was fired for dating his subordinate and not disclosing it to the employer. The California Court of Appeals said there's no private right of action under Section 96. It's a bit of a risky move to do that sort of thing, but it is employment at will. So we're very much open, and I think you should be guided by business purpose. If there are reputational issues with your VP of finance being an exotic dancer at night, I think the courts will recognize that in the balance. But blanket rules are likely to get a lot less respect. I think that'll do it. 41 minutes and 25 seconds in. This should conclude the show.